Allgeyer versus Louisiana involved the Allgeyer Company, which was a cotton company based in Louisiana, incorporated in Louisiana, and they had a shipment of cotton going across the Atlantic to Europe, and they contracted with a New York corporation called the Atlantic Maritime Insurance Company. Louisiana had a law banning its in-state corporations from contracting for insurance with any out-of-state corporations unless those out-of-state corporations were regulated by the insurance authorities in Louisiana and thus comply with Louisiana law. Allgeyer, therefore, was subject to a fine by the state of Louisiana, and instead of paying the fine, they sued in federal court, arguing that the law in question was unconstitutional as a violation either of their due process right to liberty or of the Equal Protection Clause. The Supreme Court decided 9-0 in favor of Allgeyer. The court ignored the equal protection issue entirely and issued broad dicta stating that the 14th Amendment's due process clause protects the right to pursue an occupation, to use one's faculties in all lawful ways in terms of pursuing the occupation or otherwise engaging in constitutionally protected activities. So Allgeyers often come to stand for that broad proposition, but the narrow holding of the Supreme Court was simply that Louisiana could not legitimately assert authority over a contract that was made in another state, and that the contract was made under another state's law. So Louisiana was acting within its police powers to regulate insurance contracts within Louisiana, but it was acting beyond its police powers, trying to exercise jurisdiction over contracts that were undertaken outside the state. But while Allgeyer has gone down in history as the first Supreme Court case to not only endorse a right to liberty of contract, but to enforce it against the state and have the plaintiff challenging the regulation, the phrase liberty of contract does not actually appear anywhere in the opinion, and the court did not really express a general right to liberty of contract. The case in practice stands only for the proposition that a domestic corporation in a state has a right to engage in contracts out of the state without being subject to the regulations of the state where it's domiciled. So it's a pretty narrow holding, but over time, the case was cited in liberty of contract cases as a case in which the Supreme Court recognized the right to liberty of contract. So it was often conflated with cases like Lochner versus New York or Atkins versus Children's Hospital as a leading liberty of contract case. So that's an exaggeration at best, but it does represent the first time in the modern era where the Supreme Court not only addressed an issue involving liberty of contract, but actually ruled in favor of the party who was challenging the regulation in question.